It's an honor for me to be here. I thank you deeply to AUIPO and ARISE IPR Plus team to make this event possible. And hello for everybody here. Firstly, I would like to give you a brief introduction about intellectual property rights to refresh our mind about IP. I believe that all of you have got a good knowledge about IP and GI, but let's us refresh together. I would like to share my presentation. The first topic, this first session, we would like to discuss about introduction to GI product specification. And let us remind the definition of GI. There are several definitions actually provided in international legal instruments related to intellectual property. So the most famous definition one we can find in TRIPS agreement, Article 22nd, 1. It said that geographical indication is indication which identify a good as originating in the territory of a member or a region or locality in that territory where a given quality, reputation, or other characteristics of the good is essentially attributable to its geographical origin. So based on TRIPS, a geographical indication is an indication. So it's quite the same with trademark. Now, we've got another international legal instrument called Geneva Act. Geneva Act is actually a part of what we call it Lisbon system. Lisbon system is regulated based on Lisbon Agreement. Geneva Act of the Lisbon system of 2015 said in its Article 2.1 II said that geographical indication is any indication protected in the contracting party of origin consisting of or containing the name of a geographical area or another indication known as referring to such area, which identifies a good as originating in that geographical area where a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. If we compare both definitions, we can see the similarity of them. Actually, the definition in Geneva Act is somehow inspired by the definition of geographical indication in TRIPS. Because firstly, Lisbon system did not regulate geographical indication. Historically, Lisbon Agreement 1958 was only introduced the matter regarding appellation of origin. So by the time we know that the importance of protecting GI worldwide is raised, and then members of old Lisbon Agreement were only several states. So our Lisbon system tried to open the possibility to also protect geographical indication. That's the story behind Geneva Act that was endorsed in 2015. Now, I think in ASEAN countries, we've got two countries who have been a member of Geneva Act of the Lisbon System. Okay, so we can compare that geographical indications is merely the same. The difference is that in TRIPS system, we only define the geographic indication is an indication. But according to Geneva Act, yes, it is an indication, but it can consist a name of geographical area or another indication. Okay. Now, yeah, after I remind you about the history of Geneva Act. So in Geneva Act, there are two definitions actually regulated in Geneva Act. Firstly, geographic indication, and secondly, the appellation of origin. Actually, appellation of origin is older, being regulated by Lisbon system rather than geographical indication. In Article 2.1I of Geneva Act of the Lisbon Agreement, it is said that the definition of appellation of origin is any denomination protected in the contracting party of origin consisting of or containing the name of geographical area or another denomination known as referring to such area which serves to designate a good as originating in that geographical area where the quality or characteristics of the good are due exclusively or essentially to the geographical environment, including natural and human factors, and which has given the good its reputations. Even though not all ASEAN member countries have ratified Geneva Act, but drafting geographical indication product specifications always include the elements mentioned in the definition of appellation of origin. What is it? It is the link should be that we should establish between the product and its geographical origin. And how to establish this? By drafting the geographical environment that can consist natural and human factors. So later on, we will also try to learn about how to draft the geographical environment of the GI, even though we haven't ratified Geneva Act. Because, yes, because it is a best practice. Now, experts say that GI is a part of conventional IP. Conventional IP means the system that is based on the international IP conventions and agreements. That's why we call it conventional, because it is based on conventions. Notably, the agreement on the trade-related aspect of intellectual property rights conducted by WTO substantiates the conventional IP regimes. So if now we say about conventional IP or IP, most of us refers to IP. Those are substantiated in TRIPS agreement. And geographical indication is one of the subject matter of TRIPS agreements. Interestingly, geographical indication is the only conventional IP that is held by non-individual holders. We call them collective holders. Some experts say it's communal holders, but non-individual holders. We know that maybe in one of ASEAN countries, there is a possibility to make an exceptions. In certain conditions, an individual can hold geographical indication, but it is exception. In general, GI system is collective based, communal right, we call them, beside collective marks and certification marks. So these are IP or intellectual property subject matters substantiated by TRIPS agreement. Firstly, copyright. Secondly, patent. Thirdly, trademarks. Fourthly, geographical indications. Fifthly, industrial designs. And then design of integrated circuit layouts, confidential information, and new plan for and confidential information. We call these subject matters as 7+1 because new plant variety is not regulated in TRIPS agreement, but is regulated specifically in UPOF. But theoretically, all of them are conventional IP protections because they share quite similar nature. Again, instead of all of them, which mostly dealing with individual holders, geographical indication dealing with community, with collective holders. And maybe if we would like to remind a bit that the scope of protections is different. Copyrights dealing with artistic works and literary works, okay? Patent with technical inventions. Trademark with a sign, it's similar with GI, but different because trademarks dealing with distinctive mark. Geographical indication instead, not a distinctiveness that's important, but the clear indication to the geographical origin of the product. And industrial designs, dealing with design, it used to be a visual works. It used to be a copyrights when the design is would like to be produced in massive amounts. It can be registered as industrial design. And also we know design of integrated circuit layouts is very specific because it's a design related to the technological appliances. And confidential information as well is it's more closer. Confidential information is closer to patent because before an invention is patented, it used to be a confidential information. Okay, but later on, if we draft the specification, GI specification, some of the part of GI specification can be regarded as a confidential information as well. Why? Because it is the trade secret or the secret information about the business strategy, for example. So we can include actually some confidential information in our specification later if necessary. And plus new variety of plants is dealing with like the title, the new plant variety. Now about right holders of GI. As we aware, GI is the only conventional IP held by community, non-individual holders. But the right, some experts said that the right held by GI right holders is actually not an exclusive ownership, but exclusive right to use the GI. Okay. Okay, and maybe we wonder who can be the GI associations or the community held a GI. Actually, right holders of a GIs, we can say it as a collective management organization on GI or CMOGI, or a producer associations who hold an exclusive right to use a GI can consist of some forms of communalities. It can consist of local producers and or processors of the specific products. It can also consist of local or traditional farmers or breeders of animals, and can be plant breeders as well as animal breeders. And it can also consist of local operators, landowners, and even indigenous community, tribe or clan. In Indonesia, several GI are held by indigenous community, and also local artists who live and create their artistic works as a collectivity, especially in forms of artistic handicrafts, who live in the region. They can be a holder of GI too, local artists and local traders, but most of the time, local traders should have connections with the producers, or maybe the producers act as local traders as well. Some countries also give the possibility for local government to become the holder of GI. But this is insofar that the local government acts on behalf of producer associations who live in that territory. State even can also hold a GI. It's uncommon, but some countries allow or maybe substantiate that GIs are held by state. But of course, state have to act on behalf of the producer associations. So the right of the state is a little bit different with the right held by local producers. The state is acting, it should be acting mostly as the holder of management rights. So state has a right to manage and to protect the producers rather than being a new competitor of the producers. Okay, so state could be a right holders of GI as well as other communities, insofar that the state acts on behalf and to be more beneficial for the producer associations. Now, what's the importance of GI specification? GI specification may be one of the most difficult document to draft in IP, together with drafting maybe patent specification or then variety. The documents of a GI specification can consist of more than 100 pages. But why? Because we've got some elements to cover. But don't worry, I believe that you will be an expert. You've already an expert, actually, I believe, but we can work together to develop our ability to draft it. So what's the importance of GI product specification? Firstly, as we all know now that it's being a substantial requirement of GI registration, because GI, the right, the exclusive right of GI can be obtained through registrations. We call it constitutive basis rather than non-constitutive basis. So registrations is necessary to obtain the right, but registration cannot be done without the GI specification. So GI specifications, once again, is a substantial requirement for GI registration. It also forms a legal basis to grant an exclusive right to use a GI. So we in communal rights, we have a concept of an exclusive and inclusive right. Inclusive right is more flexible because many people outside the community can also hold the products and manage the product, or maybe use the product. Yeah, that's the theory. But being an exclusive right means that the holder has the strong right to hold it and exclude the others from holding it unless the others become the members of the collectivity. So by drafting a GI specification, it is a formal legal basis to obtain that exclusive right. Only members of community or CMOGI who have been included in the specification have the right to use the GI. Others cannot. It's also establish the geographical originality of the product. That is the most important thing in GI specification. It is the causal link, cause and effect link between the product and its geographical origin. And it also forms a legally binding contract within the members of the CMOGI to protect, to implement the production methods, and to conduct a controlling mechanism resulting in the best quality of the products possible. This is what we have to remind ourselves, that GI specifications is not merely one requirements to obtain the right through registration. It is a legally binding contract within the members. So the members of the association should know the details later after we draft it, should know the details about the specification, should know that they are bound by the rules and the specifications, and they cannot fail to implement the rules. Okay, if they fail, they have consequences, unpleasant consequences, of course. Okay, so that's the importance of GI specifications for members of communities. I'm aware that some of you are members of communities, okay, or the leader of the community. So the specifications is a kind of contract, actually. It's also provide the consumers with a solid guarantee regarding the GI products, reputations, and quality and characteristics. Mr. Tiago said that once the products have been protected, once the type of products have been protected by GI, the value raised significantly. That's true. Because the consumers, one coffee expert said, if you see the reputable coffee protected by GI, you will see the consumers buy it close eyes. They don't care about, they don't have any worry to buy, to spend more money to buy that coffee, because the consumers have believed that the GI protected products have a certain quality, has a premium quality, never been the rejected or low quality, never been. Okay, so that's the importance of the specification to give the consumers a solid guarantee about the quality and characteristics in the product. Now, we've got several different protection systems on GI in ASEAN member countries. Please correct me if I'm wrong. I would like to, in this first session, review the protections among us. It is because in TRIPS, actually, there is no obligation to regulate or protect geographical indication in a certain way. Unlike maybe copyrights or patents, actually the way we protect copyright or patents according to TRIPS are clearer and more homogeneous, more unified, rather than protections of GI. There was a history about it. I don't want to talk about it, but in short, in TRIPS, or all contracting parties or members of TRIPS shall provide a legal means to protect GI in the domestic level, whatever the form of the legal means is. So that's why, because all ASEAN member countries have been members of TRIPS agreement, we are actually free to decide in our domestic level or in national level the best legal means for our country, actually. So it results in the different models and versions in protecting GI. Firstly, under the general trademark system, especially collective and certification marks. And secondly, by establishing a sui generis legal systems, especially for geographical indication. What does it mean by sui generis, Miranda? Okay, maybe some of you have known. I believe that some of you have been aware about the meaning of sui generis legal system. Sui generis legal system means the specific or special systems for certain products or way to protect that is different from the general system. We call it sui generis system because some of the experts said that actually geographical indication is a part of trademark protection system. But geographical indication is a descriptive trademark. Descriptive trademark doesn't have a strong capacity of distinguish. So it is a weak trademark. Expert of GI said, wait, it doesn't mean that that way, because GI is it is a sign, but it is not a trademark. It's different. Okay, so it's the same if we call them they are signs, trademarks, and GI have a logo, right? Deal with logos, but they're different. So we have to make the difference subsist in special law, not a general law, but special law. in this special law, some of the rules in the general law can be disregarded. Okay, so that's the meaning of sui generis. Sui generis law are used for protect geographical indication, to protect genetic resources and traditional knowledge and traditional cultural expressions in the general IP system. Because in the general IP system, if GI do not be regulated based on a specific rules or laws, it is weak. It cannot be protected properly. That's the reason. Okay, so that's the meaning of sui generis. It is a special law because otherwise, without sui generis system, it cannot be protected properly or strongly. And some of the countries also give the possibility for the producers to apply the protections for their products under either collective marks or geographical indications. So some countries have combinations or hybrid models. All of ASEAN countries have been a member of TRIPS, so we actually are influenced by TRIPS version. But 2 of ASEAN countries have ratified Lisbon system, so we have to draft our document specifications in compliance with Lisbon version 2. And Lisbon has a strong details about the specification, especially how to establish the link between the product and the geographical origin and the controlling system. So for the participant who come from the countries who have ratified Lisbon systems, please kindly note that in drafting the specification document, we have to be an expert in drafting the link between the product and the geographical indications. As we already learned from the definition, right? And then the controlling system as well. Why? Because historically, appellation of origins used to be called as controlled appellation of origins. So the controlling system is very strong in Lisbon system compared with in TRIPS system. But we will learn the controlling system from Lisbon version to be applied lighter maybe, but to be applied in TRIPS versions specification. Why? Because it's good. It makes the protection working. It makes the quality guaranteed. Okay. Now, this is the models of GI protection in ASEAN member countries from the latest data I've got from a RISE Plus team. Brunei, Jerusalem, and Philippines choose the protection of geographical indication under the general trademark system. As I already mentioned, actually, geographical indication under the trademark system is a weak trademark because geographical indication is an explanation of a place, right? It is a descriptive trademark, and descriptive trademark has a low capacity to distinguish. It is a weak trademark. However, what we can learn from the system who support the protection of GI under trademark, like United States of America, a GI can be protected under trademark as a collective mark if there is a secondary significance to make that descriptive trademark more distinctive through use. So, for example, if we say that Sumban is closed, Yeah, it has been registered under GI, but it is we plan to register them in Indonesia. It is a fine clothes, woven clothes from East Nusa Tenggara, Sumba woven clothes. Okay. If we said that it is a Sumba woven clothes, Sumba, the term Sumba is a descriptive name, right? Because it simply denotes that that fabric comes from Sumba, full stop. It has no distinctiveness, or maybe a weak distinctiveness, but we can make it more distinctive by the reputation. Sumba woven clothes has been inscribed in UNESCO as a intangible heritage of humankind because of its uniqueness and the story inside it, and the all of the Sudanese people living in oral tradition, so they speak not by words but by waving the clothes. So you can read the wisdom by looking at the ornaments in the clothes. That's unique, right? Okay, so Sika woven clothes. It's similar with Sumba woven clothes from the same region. Actually, it has been registered as a geographical indication. So by saying Sika now, most consumers refers to the woven clothes rather than the place. That's how reputation works to increase the distinctiveness of a GI. So if a GI name has got reputation through use, the reputation can be regarded as a secondary significance, not the primary, because the primary has been gone. The secondary significance to be distinctive, thus it can be protected by trademark. So only GI with reputation, who has got a reputation, can be protected by trademark. Okay. Now, we've got Brunei Darussalam and the Philippines, who provide the protection for GI under trademark systems. And most of ASEAN member countries actually choose to create the sui generis geographic indication system to protect the national GIs as well as foreign GIs registered in their territory, their jurisdictions. Cambodia, Indonesia, Thailand, and Laos PDR have got sui generis GI system. And some of ASEAN member countries, notably Malaysia, Singapore, and Vietnam, provide trademark system together with geographical indication as options to protect a potential product. So Malaysia, Singapore, and Vietnam give options. Potential GI product can be protected under trademark system, a special or collective mark, or geographic indication system. The regulations of trademark and GI allow it. Myanmar, quite different, because Myanmar has sui generis GI system, but it is attached under the general trademark system. So we can regard Myanmar as a special system, or it can be a hybrid system too. But yeah, it's a more GI sui generis GI system, but still under trademark system. GI in Brunei is protected under the General Trademark Protection System, especially collective mark, and the protection against unfair competition in business practices, especially certification marks. Object of GI protection in Brunei covers agricultural and non-agricultural products. Theoretically, GI on services, because they call it products instead of goods, can also be protected under certification marks. However, because of domestic policy in GI in Brunei Darussalam doesn't cover or not applicable for wines and spirits. Philippines, GI in the Philippines is protected under the general trademark systems similarly with Brunei, especially under collective marks based on the Philippines trademark laws. Object of GI protection in the Philippines cover similar with Brunei, agriculture and non-agricultural products. GI specification can be used as an additional or compulsory or facultative document in the application of trademarks or certification marks, because we know that applying for protection in the trademark system doesn't require the special specification, but you may put the specification as an additional, either compulsory or facultative requirements if the product is GI potential. GI specification under collective marks should mainly substantiate the reputation of the product. Okay, so the reputation should be clearly substantiated in the specification where the general trademarks prevails. In Cambodia, Cambodia is protected by law on GI and declaration of procedures for registrations and protections of GI and Geneva Act of the Lisbon System. So Cambodia is one of us who have been a member of Lisbon Agreement or Lisbon System. The elements of GI specification in Cambodia are name of GI, type of GI, the GI labels, characteristics, production process, geographical area, and of course, the link between the products and the geographical territory, and process and quality control, controlling body and competent authority, and of course, the members of the right holders. In Indonesia, GI in Indonesia is protected actually by law on trademarks and GI. So that law consists of two sections, two books, the unity of two books actually. And government regulation number 51 year 2007, and the Ministry of Justice and Human Rights. The elements, similar, name of GI, name of the protected good or products, and the GI label, and the characteristic and quality of the good or products, and the link, the production process, the method, the map, and the right holders. But in Indonesia, the requirements of GI is quite higher because it adopts also the requirements provided in Lisbon System. So actually, substantially, it's a combination of TRIPS and Lisbon system. In Thailand, Thailand protects GI through GI Protection Act. Elements of GI specification in Thai includes the photograph of GI product, the description of the production process, GI label, GI map, the description of the linkage, the descriptions about quality, reputation, properties, or other characteristics of the product, and document indicating that the product does originate from the specific geographical area. In Laos, Laos provides protections for GI under several national law as well as ratified international legal instruments. And just like Cambodia, Laos has been a member of Geneva Act of the Lisbon System. The elements of book of GI specifications include a specific geographical area of the production, condition of the products, process of quality controls, especially internal controls conducted by the members of the CMO of GI, list of the GI producers and operators, of course, the memberships of the the CMO, and the rules pertaining to controlling targets, as well as the internal regulation of the Right Holders Association. In Myanmar, protects GI through trademark laws, and I'm sorry if I misspell it, Pi Daung Su Liatao law. That's the sui generis law, especially for trademarks and GI law. Elements of GI specification in Myanmar include name, nationality, and address of the applicant, GI name, the region of GI production, the description of the products, significant features, quality, or reputation of the products, and link between the features, quality, or reputation of the product and its geographical origin. In Malaysia, Malaysia protects GI by GI Act 2000, year 2000. Elements of GI specification in Malaysia include geographical area consisting the demarcation map, including the proof of origin, the class of the goods, descriptions of the product, the quality, reputation, or other characteristic of the goods, and causal link between geographical area and the quality, reputation, or other characteristic of the good. It also includes the specific steps in production that must take place in the identified geographical area. This is very strong, actually, Malaysia. Hello. Participants from Malaysia is very strong because it's like the PDO in European Union, because the productions must take place in the identified geographical area, 100%. Right. Please correct me if I'm wrong. Okay. In Singapore protects GI through GI Act as well as Trademark Acts. Elements of GI specification in Singapore includes category of the goods. Singapore has the most variable categories of GI in all member countries, actually. And geographical area, description of goods to which the GI applies, particular characteristics differs from other goods of the same category. I'm sorry, I mistyped it. Quality, reputation, or other characteristics essentially attributable to the geographical origin. This could relate to natural and or human factors, or the reputation of the good that is essentially attributable to the place of origin. Actually, this is a typical TRIPS version. TRIPS version. Okay, Vietnam. Vietnam have a bunch of law dealing with geographical indications, my friends. So I cannot detail all of them, but Vietnam does have a big concern to protect GI, and a lot of provisions have been provided in the many legal instruments in Vietnam to protect GI. And elements of GI specification in Vietnam covers GI name, description of GI product, natural and human factor, link between the characteristic and the quality or reputation of the product and the geographical origin, the map, the proof of the products originated in the geographical area, and this descriptions of a local and stable method of production, and the mechanism of self-control.